The Gbese District Court in Accra on Tuesday adjourned proceedings involving social media personality and businessman Frederick Kumi, popularly known as Abu Trica, as the court continues to examine complex legal questions arising from an extradition request by the United States government. The case, which has attracted intense public interest and significant media attention, is not a criminal trial on guilt or innocence under Ghanaian law, but an extradition hearing to determine whether legal conditions exist for Abu Trica to be surrendered to U.S. authorities to face charges there. The court fixed February 7, 2026, to deliver a ruling on applications and arguments presented by both the prosecution and defense. Proceedings at the Gbese District Court began under tight security, with officers stationed at the entrances and within the courtroom. Abu Trica was escorted into court under police guard and took his place as proceedings commenced. Members of the public, legal observers, and media personnel were present, reflecting the national attention the matter has drawn. Relatives of the accused were also seen in court, some visibly emotional during the hearing. The two individuals previously named as co-accused, Lord Eshun and Bernard Aidoo, were also listed in the day's proceedings, although developments later in court significantly altered their legal standing. Court officials and counsel repeatedly clarified that the matter before the Gbese District Court is strictly extradition-related. Under Ghana's Extradition Act, the court's role at this stage is to determine whether the procedural and legal requirements for extradition have been met, including whether the request is valid, supported by appropriate documentation, and consistent with the Ghanaian law and international obligations. The court is not determining guilt, and no factual findings on the alleged offenses have been made by any Ghanaian court. According to filings referenced in open court, authorities in the United States have requested the extradition of Abu Trica in connection with alleged fraud-related offenses said to involve victims outside Ghana. U.S. prosecutors allege that the offenses form part of a wider international scheme. Ghanaian authorities, including the Economic and Organized Crime Office, EOCO, arrested Abu Trica following cooperation with international law enforcement agencies. These allegations remain unproven, and Abu Trica has not been convicted of any offense either in Ghana or abroad. One of the most significant developments during Tuesday's hearing concerned the two individuals earlier named as co-accused. The Attorney General's Department, representing the state, informed the court that it intended to withdraw charges against Lord Eshun and Bernard Aidoo, indicating that the state would not proceed further against them at this stage. The prosecution explained that the decision was based on an assessment of the evidence available to the state. However, the court did not immediately grant a formal discharge in the manner requested, leading to extended legal debate in open court. Counsel for Abu Trica raised several legal objections following the state's announcement. The defense argued that some of the allegations against Abu Trica were framed as conspiracy-related. Counsel submitted that, as a matter of law, a conspiracy charge cannot properly stand if alleged co-conspirators are no longer before the court. According to defense submissions, once the state indicated it was no longer pursuing the case against the two other accused persons, the legal foundation for maintaining certain allegations against Abu Trica became questionable. Defense lawyers also raised concerns about procedural fairness, arguing that continuing proceedings without clarity on the status of the co-accused could prejudice their client. They urged the court to consider an immediate discharge or to halt the proceedings pending resolution of the legal issues raised. The Attorney General's Department strongly opposed calls for an immediate discharge. State prosecutors emphasized that the matter is not a domestic criminal prosecution, but an extradition process governed by statute. They argue that extradition proceedings do not require the same evidentiary thresholds as a full criminal trial, and that the withdrawal of charges against the co-accused does not automatically invalidate the extradition request concerning Abu Trica. The prosecution further reminded the court that a motion for stay of proceedings had already been filed and was pending determination, making it inappropriate to issue a final decision without addressing all pending applications. In remarks during the proceedings, the presiding judge acknowledged the complexity of the legal issues raised by both sides. The court noted that extradition law occupies a distinct area of legal practice, involving both domestic legislation and international obligations. The judge declined to issue an immediate ruling, and indicated that the court required time to study the arguments, review applicable laws, and assess the implications of the state's position regarding the co-accused. At the conclusion of the hearing, the court adjourned the matter to February 7, 2026, at 11:30 a.m., when it is expected to deliver a ruling on the issues raised. Until that date, Abu Trica remains subject to the court's existing. The case has generated widespread discussion on social media and in public discourse, largely due to Abu Trica's prominence and the international dimensions of the allegations. Legal analysts have cautioned the public against drawing conclusions, stressing that extradition proceedings are preliminary in nature and do not equate to a finding of guilt. And this is what his lawyer said.
The legal system has been taking back 2,000 years. We have come to meet Pontius Pilate in court. The states, by its own reason and evolution, says that A2 and A3, they do not desire to continue with them, and therefore they should be discharged. That is what the state is saying. However, the judge, who was assigned to sit on the matter today, says that no, she's not going to discharge them, but defer that to the substantive judge. This is most unfortunate. At the last agenda, the court ordered that the state should have 5 weeks. If they have any information or any evidence, they should bring it before the court to justify why the court will proceed against A2 and A3. The states, in 3 weeks, have realized that they can't find anything against them. So why should their liberty be curtailed? This should not happen to anybody. Even when the person clearly is seen committing a crime, it shouldn't happen to the person. Let alone a person that there's no warrant, there's no order, there's no evidence against, to be held in custody. This is a travesty of justice.
It's unlawful.
And permit me to say, we more or less could tell something like this is coming up. We have already filed an application at the High Court to have all the 3 of them bailed. And we have also filed additional applications to quash everything that is going on, because the illegality cannot be allowed to stand. So on the 20th of January, we'll meet at the High Court. We'll meet High Court complex. No matter what, the liberty of these innocent Ghanaians will be restored. Justice will prevail. Thank you. 20th. Every law that the state is relying on to proceed against A1 is what they call a treaty. There is nothing like a unilateral treaty in this world. All treaties are either bilateral or multilateral. That law, as we speak today, does not apply in the United States of America, and therefore it cannot apply in Ghana. The United States of America has moved on from that law, and that law wasn't even between Ghana and the US. It was between the UK and the US. So if the 2 of them decide not to use that law again, why is it being used against our nationals? And please, all of you, kindly look for that law and read the condescending description, the disrespectful description that law gives to us, all of us, and not just us, including our president, our former president, our chief paramount. They call us what? Subjects and possessions of His Majesty. Which of us is a subject of His Majesty? Which of us is a possession? Are we in slavery? Are we under colonization?
No.
How can such a law be used?
It cannot.
If it is not applicable in US, why is it being applied here?
No. It's unfair.
And you see, the state shouldn't try to be mischievous with us.
Yes.
They are trying to create the impression as if there's a reciprocal thing going on with the former finance minister. The former finance minister is not being held on any extradition issue. Whatever is happening to him there has nothing to do with extradition, because the Americans themselves know that that law does not apply in their country, and they cannot use an unapplicable law to extradite the former finance minister. So why will it be used against our nation? To call us subjects, possessions. Are we goods?
No.
To be possessed by His Majesty. Who is His Majesty? Please, let everybody drum it out there. This injustice is not only on these 3 innocent Ghanaians. It's on all of us, irrespective. Because tomorrow, it can be me. And we have to be scared.
Tuesday's proceedings at the Gbese District Court underscore the legal and procedural complexity surrounding extradition matters, particularly those involving multiple jurisdictions. As the court prepares to deliver its ruling in February, the case continues to serve as a test of Ghana's extradition framework and the balance between international cooperation and individual legal protections.